Ever wondered how someone can end up behind bars without bail before they've had their day in court? Let's talk about one of the most misunderstood parts of our legal system.
What is that?
Dangerousness hearings. So picture this. You're arrested, brought to court for an arraignment, and then boom, the prosecutor drops this bombshell called dangerousness. Suddenly, you're looking at possibly spending months in jail without bail, even though you haven't been convicted of anything yet. Crazy, right? So here's the deal. A dangerousness hearing in Massachusetts is basically the court's way of saying, hey, we think this person might be too risky to release back into the community while their case is pending. And the consequences, they're massive. If you're held on dangerousness, we're talking up to 120 days in district court or a whopping 180 days in superior court. That's potentially 6 months of your life gone before you even had a chance to fight your case. Now, here's where things get really intense. Once the Commonwealth files for that dangerousness hold at your arraignment, you're stuck in custody until your actual dangerousness hearing happens. Sometimes that's the same day if you're lucky, but it can also take a week or more. That's a week of your life, your job, your family time, all put on pause. So how do you fight back against this process? Well, first, you have to understand what the prosecution needs to prove. They can't just say, hey, this person seems kind of sketchy. They have to demonstrate two crucial things. One, that you're actually dangerous. And second, that no conditions of release could possibly protect the community or the alleged victim. This is your opportunity. At your dangerousness hearing, you need to hammer home not only that you are not dangerous, but there are definitely conditions that could keep everyone safe. So what kind of conditions are we talking about? Well, GPS monitoring is a big one. Think about it. If the court knows where you are 24/7, that's a pretty solid safety measure. There are also stay away orders, regular check-ins with probation, and other creative solutions your attorney can propose. So what will the judge consider? They'll look at your criminal history or lack thereof, how serious the current allegations are, and your ties to the community. This is why having an attorney you trust is absolutely critical. They know how to highlight the positive factors and minimize the concerns. See, here's something most people don't realize. If you are held on dangerousness, you actually gain one important right, the right to a speedy trial. The law says your trial must happen within the period of your dangerousness hold. That means within those 120 or 180 days, and potentially even faster, since the language says as soon as reasonably possible. So which cases typically face dangerousness hearings? The big ones are domestic violence, firearms charges, serious drug cases, especially trafficking, violent offenses. See, the stakes couldn't be higher. Being held before trial can devastate your life. You could lose your job, your housing, even custody of your children, all before you've been found guilty of anything. But remember this, the time to act is now. If you're facing charges that might trigger a dangerousness hearing, getting an experienced attorney immediately isn't just important, it's essential. Your freedom literally depends on it. Don't face this battle alone. The system is complex. With the right advocate fighting for you, you can protect your right and your liberty when everything is on the line.